Listen.
First, let me stress, the community is not at risk because of this bond. Yesterday, as you all know, the cases were scheduled for preliminary hearing. During the transport, Mr. Siders fell and had a medical issue that required treatment and assessment. Oblenis Hospital was where he was taken, and it was determined at that point upon some tests that Oblenis did that Mr. Siders Sr. has a serious medical condition that requires specialized care in a hospital outside of this area. Practically, and I don't know if you folks know this or not, but when defendants are housed in county jails, it is the county's responsibility to pay for the medical care. Prisons are for defendants who have been convicted. Then the state pays for it. But he's still an innocent man that has not been convicted yet. So the county was going to be on the hook for his medical care. And again, based on the information that we were provided, his medical care could potentially bankrupt Vinton County. We were not going to put that burden also on our local taxpayers. And so it was agreed that we would do a recognizance bond so he could get the medical treatment that the doctors say he needs, and won't cost the county that money.
He walked out of custody not because a judge believed he was innocent. He walked out because keeping him in would have bankrupted the county. Sit with that for a moment. A 73-year-old man facing 16 counts of child endangering was released on his own recognizance, and the prosecutor said it plainly, on camera. The concern was not his guilt. The concern was the invoice. That is where this story actually begins. Not with a warrant, not with a date. With a man in a wheelchair, fresh off a fall during his own transport to a preliminary hearing, being told he can go home to get treatment the county cannot afford to give him behind bars.
Continuing concerning behaviors, but also saw some physical issues. Mr. Siders himself, expressed discomfort. So I asked the staff there if they get him checked out. Happily, they did. And when they took him to get checked out, it appears that there were some pretty significant medical issues that were discovered that required pretty significant and immediate treatment. So at this point, obviously, he's been released for those reasons.
Everything else in this case unfolds from that single, uncomfortable fact. This is the Siders case out of Vinton County, Ohio. And if you have followed it, you already know the basic shape. If you have not, here is what you need before we go further. On June 30th, deputies and agents with Ohio's Bureau of Criminal Investigation executed a search warrant at a home on Rice Street. Inside, they found 16 children, ages 1.5 to 18.
It's the same charges. All have pleaded not guilty to the counts. The charges, as I've been telling you, stem from Vinton County deputies and agents with Ohio's Bureau of Criminal Investigation finding Gary Jr. and Elizabeth's 16 children in the house on Omer Street more than a week ago. It was June 30th when deputies and agents said they went to the house to execute a search warrant as they investigated a crime that has yet to be disclosed. The search warrant was not part of the 4 misdemeanor public indecency charges that Gary Jr. faces. I want to be very clear about that. 16 children between the ages of 1.5 and 18 were found in that home, and some, according to prosecutors, were in bad shape. All were taken to hospitals throughout the state, and all have since been released and placed in foster care. One of the big questions here.
Some were described by prosecutors as being in bad shape. All 16 were taken to hospitals. All 16 have since been placed in foster care. 4 adults now face charges: Gary Siders Jr. and his wife Elizabeth, Gary Siders Sr. and his wife Christina, who goes by Lynn. All 4 have pleaded not guilty. And here is the detail that should stop you before you form an opinion about anyone in this story. Elizabeth was 15 years old when she married Gary Jr., who was 18. That marriage took place in West Virginia in March of 2008. Their first child arrived shortly after. Now the man at the center of our cold open, Gary Siders Sr., 73 years old, wheelchair-bound by every account, including his own attorneys. His lawyer is Dorian Balmer, And Balmer has filed something worth explaining properly, because the internet will tell you it means one thing, and the law says something else entirely.
His lawyer is asking to receive a mental health evaluation and to determine whether he could be not guilty by reason of insanity, meaning, can Gary Siders Sr. appreciate the wrongfulness of his actions because of a mental illness or other mental infirmity? Dorian Balmer wrote, "It was clear to counsel that the defendant exhibited significant confusion about the legal process, was unable to describe the specific roles of the various participants in the court proceedings, including even the role of counsel to aid in his legal defense, and was unable to describe even basic facts about himself. The defendant was generally unable to maintain a clear and consistent train of thought throughout the interaction and was clearly struggling to understand what is going on. The defendant's conduct leads counsel to believe that the defendant may be suffering from significant mental health issues and that competency may be an issue and clear impediment in the defendant's ability to aid in his own defense. Collateral information has seemed to confirm that the defendant suffers from significant health issues, including a decline in mental function and functionality, which would be consistent with counsel's observation of..."
A competency evaluation asks a single, narrow question. Can this person understand the proceedings against them and assist in their own defense? That is it. It does not ask whether they did it. It does not ask whether they are a good person. It is, in Balmer's own words, a bedrock precondition. Without it, a case simply cannot move forward in either direction. Balmer also filed for something called NGRI, not guilty by reason of insanity. And this is where most true crime commentary gets lazy. So let's not. NGRI is not a colloquialism. It is not a legal shortcut for he's crazy, so let him go. It is a specific, narrow test. Did the person understand that what they were doing was wrong at the time they were doing it?
Just sort of getting back procedurally, if someone asks for a competency in good faith, I have in my career, and maybe this is just because I've never in bad faith made this motion, but I have never had anyone object to an evaluation to see if the defendant is competent, so long as it's made in good faith. This is not an unusual motion to be filed with the court. As I said, it's a bedrock precondition to move forward. Same thing with in that same motion, it's not atypical. In fact, it's a matter of course that I typically file both that and the motion for an evaluation for not guilty by reason of insanity, because they are very similar evaluations. And in just so your viewers know, procedurally speaking, you first have to determine if they're competent. If they're not competent, then of course you have to determine whether they are restorable to competency or not. If they're restorable or potentially restorable, they will send them to a mental health facility for restoration services to see if they can in fact be restored. If they're not restorable, then they are just deemed incompetent. And then the court is left with sort of other questions of how are we going to handle this moving forward with an individual who's not competent. If they are in found to be competent, then they will do the second part of the evaluation, which is, were they legally insane at the time? And again, you do a law show, so I'm sure you understand, but perhaps your viewers don't. Legally insane is not some colloquial throwaway term. It's a term of art. It's a term that says, did the person understand the wrongfulness of their actions?
Balmer was careful to say this himself, on camera, because he has watched people flatten the term into something it is not. He has represented clients found NGRI because they heard voices. He has also represented clients found NGRI because of dementia so advanced they no longer understood the world around them. Two very different people, one legal standard. So which is it for Gary Sr.? Nobody is saying yet, and that itself is the story. Here is what the attorney described in his own filing about meeting his client for the first time.
Thank you again for having me. As I said, as you noted, I can't really talk about certain things due to privacy issues, not only HIPAA, but also just his own privacy. We're all entitled to certain privacies. But I was asking for a modification of bond. As I've already sort of said elsewhere, I was able to meet with him after the court hearing didn't take place, but the court hearings were scheduled. I was able to finally meet with him, and upon meeting with him, I did see additional concerning behaviors. As you'll probably get into, I filed a motion for competency.
Right.
NGRI. So I saw some of those.
Significant confusion about the legal process, an inability to describe the roles of the people in the courtroom, an inability even to describe basic facts about himself. Balmer called him, in his own words, a sad and sympathetic character. Not dangerous, confused. Ask yourself something, and this is worth sitting with rather than scrolling past. What does it say about a system when the difference between defendant and patient can hinge on whether a lawyer happens to notice the confusion in time?
Yeah, and I wanted to get to that because it seems like the prosecutor didn't sound like he was going to oppose that. He even mentioned that you filed this motion, and he seemed to acknowledge and recognize that maybe there are some potential issues here.
I mean, without not trying to hide the ball here, but I think everyone saw Mr. Siders, and so I don't think it's a surprise that anyone might be concerned about his competence.
He acknowledged on camera that the concern was visible to anyone watching the preliminary hearing. That is not a small thing. A prosecutor conceding without a fight that his own defendant may not understand the case against him. So the court ordered the evaluations. A psychiatrist or psychologist will now sit with Gary Siders Sr. and establish what Balmer called his baseline. Until that happens, this case cannot move forward for him at all. Not toward a plea, not toward a trial, not toward anything. That evaluation is happening right now, while you watch this. And whatever it finds will determine whether Gary Siders Sr. ever stands trial for what happened in that house on R Street, or whether the state is left asking an entirely different set of questions about a man who may not be capable of answering for himself.
I don't know at this point. We would have to determine whether that's something that the court finds appropriate. Obviously, he is still technically on bond, even though he's been released. He's been given a recognizance bond with certain requirements, including a GPS monitor. When people are given a recognizance bond, they still have terms and conditions of bond they have to comply with. I don't know at this point. I think we're still in the early stages of what that might look like. It's up to the court ultimately where he can stay, as long as it's an appropriate facility. Then I'm sure the court would be open to that, but the court may be thinking about, again, if he has these significant mental health issues or physical health issues, then perhaps a transitional care or a transitional medical care or something else might be more appropriate. It's really going to be I don't really want to prognosticate on exactly where he'll go because it'll be up to the court.
And that is when things got interesting. Because the man in the wheelchair is not the only Siders asking the court for something. Elizabeth Siders, 33 years old, mother of 16, has asked to be released from jail. Her bond currently sits at $300,000. Her attorney, Tommy Staley, filed the motion, and it is worth reading closely because it tells you something about how the system evaluates risk that has nothing to do with guilt or innocence.
Raleigh filed this motion and wrote that Elizabeth has cooperated with the investigation. Attorney Staley wrote, "In this case, the defendant is a 33-year-old mother with no known criminal history. Given the defendant's lack of a criminal history, she has never been charged with failure to appear before a court for a criminal proceeding. There has been no indication that the defendant has been anything but cooperative with law enforcement since the initiation of this case. As such, the defendant does not pose a significant flight risk. The defendant has indicated that she will provide the court every assurance necessary, that she will appear to all future hearings and will comply with the terms set forth by this court. Should the defendant be released, she is willing to wear a GPS monitor, to check in person with her assigned bond officer at whatever frequency this court deems appropriate, and to provide the court with a stable living address within Vinton County."
It argues something narrower and, frankly, more honest. No criminal history. No history of failing to appear in court. Full cooperation with law enforcement since the case began. A willingness to wear a GPS monitor. To check in with a bond officer at whatever frequency the court requires. To provide a stable address. And then the detail that reframes the entire request. Elizabeth cannot post any cash bond because she cannot afford one. The very poverty that formed the basis of the charges against her is also, according to her own attorney, the reason she remains in jail.
Defendant is indigent. The basis of the amended complaint was that the defendant was living in a home which exhibited extreme poverty. As such, while in many cases some bond may be necessary to ensure that the defendant appears as ordered, it seems clear that in this particular case, the defendant does not have the means to post any money as a bond, and they have been unable to post the current bond as it has been set. Now, we're still awaiting the prosecutor's response to this motion. Will he oppose it? We don't know. As for Gary Sr.,
Sit with that for a second, because it is worth a comment of its own. The state's case rests partly on the argument that this family could not adequately provide for 16 children, and the bond keeping one of those parents locked up rests on an amount that same poverty makes impossible to pay. Two facts sitting in the same case file, pointing in opposite directions. Nobody raised their voice about it. Nobody needed to. The filing says it plainly enough on its own. The prosecutor has not yet responded to that motion. We do not know if he will oppose it. Now, back to the fall, because we still have not answered the question the cold open left open. Gary Sr. fell during transport to what was supposed to be his preliminary hearing. He was taken to a hospital in Oblana, and doctors there found something more serious than the fall itself, a condition Prosecutor Archer has declined to specify, citing privacy. Whatever it is, it requires specialized care outside.
I'm looking into the possibility that there might be a religious component to all of this. Christina Sider's Facebook has images of Jesus and the Lord's Prayer. She posted about God frequently and has a cross as her profile photo on one of her accounts. There are also photos of Gary and Lynn, that's Christina, from 2023, where they look well and clean. The photos are nothing like what was described by law enforcement after their arrests. And I've told you that I've learned that Children's Services in a county near Vinton once visited Gary Jr. and Elizabeth Siders. And then the couple moved with their children, I'm told, to avoid social workers, fearing their children would be taken away from them.
A children's services agency in a neighboring county had visited the family previously. The family moved. According to the reporting, they moved specifically to avoid social workers. Draw your own conclusion about what a family does when it fears losing its children, and what that fear usually means. So where does this leave us? A grand jury will eventually hear this case, though in a county this small, that process moves slowly. 2 special prosecutors have now been appointed to assist, both with extensive experience in child cases, and both, notably, working without additional cost to taxpayers.
And we discussed in the last Crime Fix the possibility that special prosecutors were being brought onto the case in case the current prosecutor would have any type of conflict of interest. But Prosecutor Archer says these cases are staying with his office in Vinton County, and Assistant Attorney General Kara Keating and Highland County Prosecutor Annika Collins will assist with the investigation and prosecutions.
The Attorney General did offer assistance and has agreed to provide an assistant AG. Her name is Kara Keating, and yesterday motion was filed to have her appointed special prosecutor to assist me in the prosecution. Also, Annika Collins, who is a Highland County prosecuting attorney, I also filed a motion to have her appointed as a special prosecutor, as she was an old colleague of mine when I worked in Highland County. Both of these women are outstanding prosecutors with extensive experience in child cases, and they will do nothing but help our team progress through these cases.
And that assistance is being provided free of charge, so the taxpayers won't be on the hook for it. And we're going to keep a close eye on this.
Gary Sr. awaits a competency finding that will determine whether he ever answers for these charges at all. Elizabeth awaits a bond decision that may hinge less on what she is accused of and more on what she can afford. Here is the lesson worth taking with you, and it applies far beyond Vinton County. Competency is not a technicality lawyers use to delay justice. It is the floor beneath the entire system. A trial cannot be fair in either direction if the person standing in it cannot understand what is happening to them. And bond is not a measure of guilt. It is, far too often, a measure of what someone can pay. If you ever find yourself watching a courtroom or sitting in one, remember that these two ideas, competency and bond, are doing far more quiet work than the headlines ever let on. The evidence in this case has not finished speaking, but it has already